Hey everyone, welcome back to the deep dive. Some topics can feel like trying to navigate a maze. And for many people, Social Security disability claims are right at the top of that list. Especially, what happens when your initial claim gets denied. That denial letter, it just hits hard. You've put in all the work, you're struggling with a condition that's, well, debilitating, and then, boom, rejection. But here's the thing, and this is really interesting. It's rarely the end of the road. So today we're taking a deep dive into why getting professional legal help for a denied SSD claim isn't just like an option. It's often the critical factor in actually getting the benefits you deserve. We'll be pulling out the key insights from our sources on this exact topic. And get this, did you know initial denial rates often top 60%? 60%. It really just underscores how incredibly complex this whole system is.
It really does. And what's fascinating looking at the data is that while those denials are super common, the numbers consistently show this dramatic difference. Applicants who hire a lawyer for that denied claim, they have significantly higher success rates during the appeals process, much higher, which, it raises a crucial question for anyone going through this. What exactly makes such a stark difference? We're going to try and unpack 8 core reasons today.
Okay, let's really dig into this then. Our research, it strongly suggests legal expertise is a total game changer, starting with the first big one. Just the sheer complexity of the legal landscape. What makes it so challenging for someone trying to go it alone?
Well, it's like this dense forest, a thicket of federal regulations, administrative rules, legal precedents that are actually changing pretty frequently. Think about the SSA's 5-step sequential evaluation process. That's their systematic flow chart, basically, for deciding eligibility. Now, an individual might just see 5 steps, but a skilled lawyer, they understand the precise criteria for each step. They know how to meet them, and crucially, how to interpret the subtle legal arguments, the administrative rulings, things that can really pivot a case, things most people would just miss.
Okay, so it's not just knowing the rules exist, but spotting those tiny, almost hidden nuances, the exceptions or interpretations that could turn a no into a yes. Can you give a quick, maybe hypothetical example, like how missing one small detail in that 5-step thing could just derail the whole claim?
Oh, absolutely. Let's say step 2 requires showing your condition stops you from doing your past relevant work. Or step 5, showing there's no other work you can realistically do. If you haven't clearly proven those specific points with the right kind of evidence, well, that's often where claims fail. A lawyer ensures those specific legal burdens are met, they're documented properly, and they can pinpoint where maybe the SSA is misinterpreting your actual capacity.
Right. That makes perfect sense. So you navigate the legal maze, but then getting your evidence right is the next massive hurdle, isn't it?
Yeah.
But surely I can just gather all my doctor's reports myself. What makes a lawyer's approach to evidence gathering so different? Is it really that fundamental?
It's fundamentally different because it's about strategic evidence gathering. You might collect records, sure, but an experienced attorney knows exactly what the SSA needs to see to actually prove your claim. It's not just proof you have a condition. It's proof of how that condition functionally limits your ability to hold down a job. They know how to track down records that can be really tough to get. They organize everything into a coherent, compelling narrative. And critically, they identify the gaps in your medical documentation, things you might not even realize are missing. They might even say, hey, you know what? We need this specific type of evaluation to get a detailed functional capacity assessment that really strengthens the case. It ensures your case isn't just documented, but it's powerfully argued through that medical history.
Okay, so the lawyer is like the architect for your case, building it brick by brick strategically. And speaking of structure, procedural compliance, those deadlines, that sounds like where a lot of people must just trip up.
Yeah.
I imagine, just thinking about navigating those deadlines probably makes a lot of listeners feel completely overwhelmed. Me too, frankly.
You're spot on. It's reason number 3, and it's where so many otherwise valid claims, unfortunately, just falters. Heartbreaking, really. The SSD appeals process is absolutely riddled with strict deadlines. For instance, you typically have just 60 days. That's it to file for reconsideration after that first denial. And then another 60 days if that's denied and you need to request a hearing. Miss even one deadline. Make a small clerical error on a form. Your case can be dismissed. Doesn't matter how strong your medical evidence is, gone.
Yeah.
A knowledgeable lawyer Well, they act as your guide through that whole bureaucratic maze. They ensure every I is dotted, T is crossed. They handle all of communications with the SSA, keep you on track, make sure nothing falls through the cracks.
Okay, so that covers the paperwork and the timelines.
Yeah.
But what happens when you finally get to face a decision maker? You mentioned the hearing. It sounds like having an attorney completely transforms that experience. It goes from being maybe a daunting interrogation into more of a structured legal proceeding.
Absolutely. That administrative hearing, it's often your best shot, sometimes your last shot. And the data we've looked at, it's really striking. Claimants who have legal representation at these hearings, their success rate is around 61%. Compare that to claimants without representation, their success rate is only about 28%. Huge difference.
61 versus 28%. That's
Yeah.
massive.
It is. And your attorney doesn't just, show up. They prepare you thoroughly. Practice sessions, teaching you how to clearly articulate your limitations, how to answer tough questions. And then in the hearing itself, they're presenting opening statements, they're objecting to unfavorable evidence, questioning witnesses, and crucially, they cross-examine the vocational experts. Then they deliver powerful closing arguments, tying it all together. It's a full legal presentation.
That cross-examination of vocational experts, that sounds like it could be a real turning point. You mentioned them briefly. Their testimony can genuinely make or break a claim, can't it?
Oh, it absolutely can. This is reason 5. Vocational experts, or VEs, they testify about jobs available in the economy and whether, in their opinion, you can perform specific work given your limitations. But here's the key. Their testimony isn't infallible, not by a long shot. A skilled lawyer knows exactly how to dissect their methodology. They question their data sources. Maybe the VE is using outdated job market info, or perhaps their assessment of your actual functional limitations is just plain wrong, or doesn't account for all your issues. Exposing those weaknesses, those flaws in their analysis during cross-examination, that often proves decisive. We've seen cases turn entirely because a lawyer effectively demonstrated that the jobs a VE suggested just weren't realistic or even available for someone with the claimant's specific set of limitations.
Okay, that makes a lot of sense. Beyond the VEs, you also mentioned building a strong medical foundation often involves other medical professionals. How do lawyers really help optimize that side of things? What kind of impact does that coordination have?
Yeah, that's reason 6, and it's crucial. Coordinating effectively with medical experts. Experienced SSD lawyers often have established relationships with qualified medical professionals. Doctors, specialists, psychologists, people who can provide compelling, objective testimony or reports. They might arrange for an independent medical examination, IME, if needed, or work with your treating physicians to get really detailed narrative reports. These aren't just notes. They truly capture the severity of your condition and exactly how it impacts your day-to-day functioning and ability to work. Plus, they ensure all these expert opinions meet the very specific medical criteria laid out in the SSA's own Blue Book standard.
Blue Book.
Right. That's essentially the agency's big detailed guide to qualifying medical impairments. It lists conditions and the specific evidence needed for each. Lawyers make sure the medical evidence aligns with those standards. They basically translate complex medical jargon into the specific language the SSA needs to hear.
Okay, so meticulous preparation, expert coordination. But what if, even with all that, the hearing still results in an unfavorable decision? Is the fight just over then?
Not necessarily, no. And that brings us to reason 7. Appeals counsel and potentially federal court strategy. These are the higher levels of appeal, and honestly, they demand pretty sophisticated legal strategies. You're really in deep legal waters here. Your attorney will meticulously pick apart the administrative law judge's decision. They're looking for legal errors, procedural screw-ups, inconsistencies, anything that shows the decision wasn't legally sound. Then they craft these detailed written arguments for the appeals counsel. And if that doesn't work and the case has to go to federal court, well, that's a whole different ballgame. It requires deep, deep knowledge of federal civil procedure, plus a really nuanced understanding of Social Security law to argue effectively that the SSA's final decision just wasn't supported by substantial evidence in the record.
Wow. Okay, all of this sounds incredibly valuable, indispensable even. But I keep thinking, for someone already struggling financially, possibly unable to work, the cost must be a huge worry. A massive barrier. Which brings us perfectly to reason number 8, and this one really seems to address that head on, right?
It truly does, and honestly, it's perhaps one of the most compelling reasons for many people. The cost-effective contingency fee structure. Almost all SSD attorneys work on what's called a contingency basis. What that means, simply put, is they only get paid if they successfully win benefits for you. And the SSA actually regulates these fees quite strictly. It's typically capped at 25% of your back pay award, the benefits that accumulated while your case was pending, up to a maximum amount set by federal regulations. Currently, that cap is $7,200, though it can change.
Wait, so you pay absolutely nothing up front?
Nothing up front. And crucially, if your case isn't ultimately successful, you never owe the attorney any fees for their time, ever. It essentially makes getting expert legal help a remarkably risk-free investment in your potential financial future.
That contingency fee model really does seem to level the playing field, doesn't it? It removes that huge financial obstacle. But just playing devil's advocate for a second, does it ever create an incentive for attorneys to maybe only take the easy cases? Or does the system genuinely encourage them to fight hard for every claimant?
That's a really fair question. And while naturally, attorneys have to assess the viability of any case before taking it on, they can't take cases with absolutely no merit. The system is definitely structured to reward success, not just cherry-picking easy wins. Attorneys absolutely take on complex, challenging cases all the time. Why? Because a successful outcome, even if it requires a lot more effort and time, ultimately benefits both the claimant, who gets much-needed support, and their practice. The core incentive is simply to win the case for their client, regardless of the initial perceived difficulty.
Okay, that clarifies things. So if someone listening has received a denial and is now thinking, okay, I need an attorney, what are the most critical things they should look for? What factors should they consider when choosing?
Yeah, that's key. Our sources highlight several important factors. First and foremost, look for attorneys who specialize exclusively, or almost exclusively, in Social Security disability law. This isn't an area for general practitioners. You really want someone with extensive experience handling appeals at all levels: reconsideration, hearings, appeals counsel, even federal court if necessary. Familiarity with the specific administrative law judges in your state or region, like, say, Virginia, if that's where you happen to be, can also be a big plus. They know the local tendencies. Definitely look for a proven track record of success. Ask for references if possible. Strong relationships with reputable medical and vocational experts are important too. And then there's the practical stuff: clear communication, responsiveness, do they return your calls, and making sure they have adequate support staff to handle the caseload efficiently. And remember, while no ethical attorney can ever guarantee approval, solid legal representation demonstrably significantly improves your chances. The statistics bear that out.
Right. And one last practical question. How long does this whole appeals process usually take? Does having an attorney speed it up, or are we still looking at a long wait?
Generally speaking, the appeals process itself, from the initial denial through to getting an administrative hearing decision, typically takes around 12 to 18 months. That timeline is often similar whether you have representation or not, largely due to SSA backlogs. However, where an attorney can make a huge difference is in helping you avoid unnecessary delays. Delays caused by, say, procedural errors, missing deadlines, or submitting incomplete documentation. They keep the case moving forward as efficiently as possible within the confines of that system, effectively streamlining your path.
Okay, so wrapping this up. After this deep dive, it seems abundantly clear. Navigating a denied Social Security disability claim. It's anything but simple. It's a complex, really multi-layered process. And it seems like expertise, precision, and just strategic advocacy can truly make all the difference in the outcome. From understanding those intricate legal frameworks we talked about, to challenging expert testimony effectively, and just managing all those strict deadlines, the value of professional legal representation feels, well, undeniable.
Exactly. I mean, the statistics we discussed really speak for themselves, don't they? They showcase that dramatically improved likelihood of success when claimants have good legal guidance. It just underscores the reality that in these big, complex systems designed with so many layers of regulation, specialized knowledge isn't just sort of helpful. It's often absolutely essential to ensuring you actually get fair consideration.
Yeah. This deep dive really makes you think, doesn't it? And in a world that feels like it's full of increasingly complex systems, healthcare, finance, legal, stuff like this, how much does having access to specialized knowledge, or maybe not having access to it, truly impact our ability to secure what we might actually be entitled to? What part of this deep dive into the challenging world of SSD claims stands out most to you thinking about it now?